Get started for today. Welcome here. Let's see, do we have any requests for bill introductions today? All right, not seeing any. We'll go ahead and move into our hearing and open the hearing on House Bill 2073. And we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2073 prohibits fines and fees from being assessed against a juvenile or a juvenile's parent, guardian, or custodian in a case pursuant to the revised Kansas Juvenile Justice Code. I'll just refer to that as the code throughout this brief. So Section 1 creates a new section of law providing that in an action under the code, no fine, fee, cost, court expense, reimbursement, or other financial obligation shall be ordered or assessed against a juvenile or a juvenile's parent, guardian, or custodian. After the effective date of this act, which would be July 1 of 2023, any outstanding court-ordered fines or fees that are owed by a juvenile or a parent shall not be collected. Any juvenile who's participating in immediate intervention, on probation, in a detention facility or correctional facility, or otherwise being supervised solely because of outstanding fines or fees shall be discharged, and a juvenile parent or guardian who is incarcerated solely because of non-payment of fines or fees in an action under the code would be required to be released from custody. That's the big provision here. The rest of the sections, and I'll go through the fines that are in each of the sections, but the rest of that is just kind of amending current fines and fees to remove and provide that those juveniles can't be assessed those fines and fees. So Section 2 amends KSA 1216-119. That's the statute requiring certain fingerprinting fees to be paid that would not be assessed in actions under this code. Section 3 amends KSA 2031-29. That's the statute that authorizes clerks of district courts to tax a library fee for the law library, and that fee will not be imposed on a juvenile or a parent under this code. Section 4 amends KSA 216609. That's the statute that authorizes the court or the Secretary of Corrections to implement a house arrest program. And that would provide that the secretary shall not require a juvenile or a juvenile's parent to pay any costs associated with that house arrest program if a juvenile is participating. Section 5 amends KSA 224905. That's a statute in the Offender Registration Act that requires people subject to registration to pay a fee when they register. And so this would provide that no fee will be assessed if the person is registering because of a juvenile adjudication. That's the one section that actually could apply to some adults because if they are required to register under the act for a juvenile adjudication, but they're an adult, they still wouldn't be assessed that fine. Section 6 amends KSA 28170, the statute that describes the docket fee for certain cases, to provide an additional $1 fee for the prosecuting attorney's training fund and the non-judicial personnel fee fund, and that wouldn't be assessed under this code. That's the same as in 28170A, the provisions that are changed there. Section 8 amends KSA 28176. That's the statute that authorizes assessment of a $400 forensic science fee. That fee would no longer be assessed to juveniles under the code. Section 9 amends KSA 28177. That's the statute that authorizes the non-judicial personnel fee, which is that additional surcharge onto the docket fee. So that fee would no longer be imposed in an action under the code. Section 10 amends KSA 382306. That's the statute that provides that juveniles are entitled to an attorney during proceedings under the code. And this section is amended to provide that the expense of those services would not be assessed against the juvenile or the juvenile's parent. Section 11 amends KSA 382312. That's the juvenile adjudication expungement statute. So no docket fee or that additional surcharge, the non-judicial personnel fee, would be imposed to a petitioner filing for expungement under that section. Section 12 amends KSA 382315. That's the statute providing for the care and custody expenses of a juvenile under the code. So current law in that section provides that when care and custody expenses have been paid out of the county general fund, the court can actually assess that expense to the person who by law is liable to maintain support of that juvenile, so usually the parent. Such person can request a hearing on the question of whether they should pay those expenses, and if they are ordered to pay, then the person can be held in contempt for failure to pay those expenses. When care and custody expenses have been paid by the secretary can cover the expenses from the person liable to maintain support of that child. The secretary can contract for collection services for those fees. So this bill strikes those provisions and provides that the expenses for the care and custody of a juvenile under the code will not be assessed to the parent, guardian, or custodian. Section 13 amends KSA 382317, the statute that requires offenders to pay the cost of certain testing to provide that no fee for counseling or testing would be assessed under the code. Section 14 amends KSA 382328. That's the statute that provides the requirements for pleadings under the Juvenile Justice Code. And it would remove the current law provision providing that the complaint can contain a request that parents of the juvenile be ordered to pay child support in the event that the juvenile is removed from their home. Section 15 amends KSA 382331. That's the statute that provides the detention criteria for juveniles, and it would provide that no juvenile shall be placed in detention solely because of the non-payment of any fines, fees, court costs, or restitution. Section 16 amends KSA 382346. That's the statute requiring juvenile intake and assessment to adopt policies on immediate intervention. Current law there contains a provision providing that juveniles can't be denied participation or be terminated unsuccessfully because of their inability to pay fines and fees, and that any fines and fees that are collected under the program will be retained by the program and used for the development and operations. This bill strikes that provision and provides that no fees or costs shall be imposed to a juvenile or the juvenile's parents for participation in an immediate intervention program, and the juvenile would not be able to be denied access to that program due to any unpaid fines or costs. Section 17 amends KSA 382348. That's the statute relating to incompetency of a juvenile offender. It strikes the current law provision authorizing one or both parents of the juvenile to be ordered to pay child support if the juvenile is committed for evaluation and treatment under the code. Section 18 amends KSA 382360. That's the statute related to post-adjudication orders and hearings. It provides that the cost of mental health evaluation and treatment and post-adjudication assessment tools would not be assessed to the juvenile or the juvenile's parent. Section 19 amends KSA 382361. That's the statute that provides sentencing alternatives for juvenile offenders. And it's changed to provide that no financial terms or conditions, including fines, costs, child support, can be placed on a juvenile or the juvenile's parent for participation in a community-based program, out-of-home placement, house arrest programs, drug or alcohol testing, electronic monitoring, or remote alcohol monitoring. It also eliminates the imposition of any fine as a sentencing option when dealing with a juvenile. The court may not commit a juvenile to detention for non-payment of any fine, fee, cost, or restitution, and the court cannot make an order with a finding that a juvenile is detention eligible based on non-payment of fines or fees or non-compliance with a parent not paying those fines and fees. Section 20 amends KSA 382362. That's the statute providing orders related to parents under the code. Current law there provides the Board of County Commissioners to require parents to pay the cost of a house arrest program. And the court can order the parents to pay child support when the juvenile is in the custody of the Secretary of Corrections. This bill strikes both those provisions and provides that a parent will not be held responsible for the cost of house arrest programs or any other evidence-based program ordered by the court, including parenting classes, and they won't be responsible for support of the child if the juvenile is placed outside the home. Section 21 amends KSA 382369. Section 22 amends 382369 in the same way, so I'll talk about them together. Those statutes provide the requirements for juvenile offenders to be placed at the juvenile correctional facility. Those changes are just technical to update cross-references that are changed in the other portions of the bill. Section 23 amends KSA 382384, the section in the code related to fees and expenses for appeals, to provide that the fees and costs of the appeal, including any transcripts or records, would be paid from the county general fund and not assessed to the juvenile or the juvenile's parent. Sections 24, 25, 26 Again, we just have statutory cross-reference changes there. And then finally, Section 27 amends KSA 75-724. That's the statute that allows fees to be assessed against offenders for the cost of DNA testing. And so this would provide that those fees can't be assessed against a juvenile or a juvenile's parent under actions under the Joe Code. And I can take any questions.
All right, thank you, Natalie. Question, is there anything in here that prohibits the collection of restitution?
Mr. Chairman, there's nothing in here that specifically prohibits the collection of restitution. There are a couple provisions saying that a juvenile cannot be put in detention solely because of non-payment of restitution. Those are the only provisions specifically related to restitution. I would point you to subsection B, paragraph 1, that does talk of, or rather subsection A there in section 1, that says that no financial obligations can be ordered against a juvenile. So it doesn't specifically call out restitution where, it calls out fines, court costs, everything else. But if that other financial obligations were to be interpreted to include restitution.
Okay, it's just something to consider. Representative Heiberger.
I'm looking at statute here. It seems like in section C of that section, it says the provisions of this section shall not apply to restitution that is owed by a juvenile.
Right, yeah, so, and that's certainly the intent, I think, of the people who requested the bill. Yep.
All right, Representative Smith.
Thank you, Mr. Chair. And I'm going to be lazy here and pick on your super legal brain. On section 17, KSA 382348. In reading through this, I missed this part until you said it out loud. The statute relating to incompetency of a juvenile offender to strike the current law provision authorizing one or both parents of the juvenile to be ordered to pay child support if the juvenile is committed for evaluation and treatment under the code. Is that child support that exists prior to the offense or child support that's current? I don't get when that.
So, yeah, and if, for those of you who are looking at the bill specifically, that provision that Representative Smith is referring to is on page 25 at lines 25 and 26. So if you look at the read-in, or the lead-in to that subsection, it says, if the juvenile is found to be incompetent, the juvenile shall remain in jurisdiction of the court and shall be committed for evaluation and treatment. So I think what they're talking about there, just like the other sections that allow for the Secretary of Corrections to get reimbursed, or the county general fund, is for the time period that the juvenile is committed and receiving evaluation and treatment for that incompetency motion, then the parents can be ordered to pay child support for that time.
Okay, thank you.
Additional questions for Natalie, committee? All right, seeing none. Thank you very much, Natalie. All right, committee, we'll start with our proponents online. We have Noah Bean, State Policy Manager for the Justice Action Network. Welcome to the committee, Noah.
Thank you so much, Mr. Chair, members of the committee. My name is Noah Bean. As the chair said, I'm State Policy Manager for the Justice Action Network, also known as JAN. We are the nation's largest bipartisan criminal justice reform organization. So in that role, we are active in about 20 states around the country, places like Louisiana, Missouri, Arkansas. I'm here to support this bill and to explain a few aspects that might be helpful in your deliberations, including some national perspective, research about how this will improve public safety, and reasons why this is an important matter of government efficiency. JAN supports bipartisanship, not simply as a slogan, but because we believe laws supported by lawmakers of all parties lead to better, more durable outcomes. And we certainly believe House Bill 2073 falls in that category. From a national perspective, eliminating fines and fees is a bipartisan reform in states across the country. That makes sense no matter your ideological vantage point. Similar reforms are the law of the land in red states right now, blue states, purple states. In 2019, Louisiana eliminated fees imposed on kids through a unanimous vote in the legislature. Every lawmaker voted in favor. They've had good success in the years since, and I will note Louisiana is a very punitive state. They have an adult incarceration rate that is the highest in the nation, certainly much higher than Kansas's, where Kansas has adopted alternatives. But in this case, Louisiana took the step of eliminating fees, and we want to highlight that, the bipartisan nature of that effort for the committee today. Imposing fines and fees on young people is so bureaucratically inefficient that it may even lose taxpayers' money in the collection process. In Oregon, for example, the state did an analysis that found over the course of 1 year, it spent $866,000 in order to collect $866,000 in order to collect $864,000 in youth financial obligations. I'll say that again. Oregon spent $866,000 of taxpayer money to collect $864,000 from young people involved in the juvenile justice system. In the fiscal note for this bill, Kansas reports about $300,000 in revenue in 2021 from young people. That's down dramatically from a few years back, which I think is noteworthy. But the point here is that there is a strong chance that Kansas taxpayers are spending more than $300,000 to collect that $300,000. This obviously makes no sense, but even more than that, we believe Kansas juvenile probation officers, victim advocates, judges, the people that work every day in juvenile justice to help families, to help kids, to work through better public safety, they deserve a better, more reliable source of funding. I'd like to briefly quote several prominent national conservative groups like Americans for Prosperity and Right on Crime, who wrote that, quote, costs imposed on youth and their families for a young person's involvement in the justice system operate as part of a regressive tax on vulnerable communities, end quote. This bill simply aims to eliminate this tax and replace the cost with more consistent funding for juvenile justice system operations. Finally, and most importantly, I simply want to highlight that there is no evidence that fines and fees on kids makes Kansans any safer. And in fact, there is evidence that financial obligations like these can increase recidivism. One very strong study in Pennsylvania found financial obligations like fines and fees were correlated with higher rates of reoffending, even controlling for other factors like the severity of the offense or how many prior offenses a young person had committed. In other words, research shows fines and fees can in fact make communities less safe. I'll just conclude by saying this is a common sense piece of legislation, an opportunity to come together to do the right thing. And if Jan can help your committee in any way in terms of research or examples from other states, please let us know. Thank you so much for the opportunity, and thank you for the time on this issue.
All right, thank you, Noah. We're going to go ahead and hold questions. We have a number of conferees, so if you have a question for somebody, be sure and write that down, and we'll circle back to that when we finish up all of our proponents. So now we'll welcome Tyler Williams from Progeny. Tyler. Welcome to the committee, Tyler.
Thank you, Mr. Chair and committee. My name is Tyler Williams. I am a formerly adjudicated youth in the state of Kansas, and I am a youth leader with Progeny. And I am here today to show support for HB 2073. So my story and testimony with the fines and fees begins with my case, which began at the age of 13. I was transported from Oklahoma City to Junction City and was charged $840, an expensive transport for sure. But my total cost ended up to be about $1,064. While adjudicated almost 6 years, any time money was sent to family, half was taken for court costs. This continued all the way until the point where I graduated high school and obtained my first job while incarcerated, where I made 25 cents an hour to $1 an hour. During my stay, I managed to pay a total of $270. Upon my release, a month before my 19th birthday, there was things such as violent offender registration, probationary costs regularly that were constantly added to that. Once I was released from probation, after getting my first job, working a minimum wage job, doing pizza, I was released from there by my county My apologies. A little nervous, sorry.
All right.
After I got my job part-time, I was released off probation, essentially told I was doing too good, that the county didn't have the funding. I guess there was some legislation changes this as well. But I essentially became homeless. With nobody in the state, I was alone, couch surfing. I began receiving regular calls stating that I had to pay $80 a week or face garnishments and potential other punishments. So again, my story is only one example of the financial burdens placed on youth. It sucks. I mean, coming from somewhere, you know, being a youth, getting out, trying to get on your feet, and then constantly keep tripping up as you keep trying to do good, it sucks, and it's unbearable. I was lucky enough, I got connected with some organizations that helped me get on my feet, but not everyone in Kansas is lucky. So if we really want to help kids rehabilitate back into society, we need to stop treating them like adults and start treating them as kids. We can't keep trapping these youth in financial burdens. Thank you.
Absolutely. Thank you, Tyler. All right, now we have Jonathan Luth, Deputy State Director, Americans for Prosperity of Kansas. Jonathan, welcome.
Thank you, Mr. Chairman, members of committee. As was said, my name is John Luth. I am the Deputy State Director with Americans for Prosperity. As one of the largest grassroots organizations in the country, Americans for Prosperity is always seeking to provide and drive for long-term solutions to a number of our country's biggest issues, one of which we feel could be addressed with the legislation before us today. And so standing here representing Americans for Prosperity Kansas and thousands of activists across the state that engage with us every day, every week, every year, we are asking for your support of HB 2073. Within my written testimony, we have provided several sources and citations for a number of studies and publications that all examine the effectiveness and impact of fines and fees within the juvenile justice system. Each of those studies, as well as numerous others that are out there, have shown us clearly that when juveniles are facing large accumulations of debts through these fines and fees, the likelihood of recidivism dramatically spikes. The likelihood of successful reentry dramatically plummets, and oftentimes this culminates in a lot of long-term, inadvertent, negative interactions within the justice systems for these individuals for significant portions of both their juvenile and then going into large portions of their adult life. Beyond the impact of these fines and fees on juveniles and their families, we have seen some serious impacts both economically and professionally within our law community. First off, data has, as has been indicated, has shown us repeatedly that the cost of chasing down these fines and fees have grown and are very high, oftentimes even outweighing the benefits from the gains of that collection. The Brennan Center analyzed data collected from 10 counties in Texas and New Mexico, and that data found that for every dollar that was spent in those two states to collect juvenile fines and fees, they were having to spend 41 cents right back into the system for the additional court hearings, court fees, so on and so forth. Additionally, a study done in Florida from 2022 showed that of all of their fines and fees, they were only able to ever recover 11% of those juvenile fines and fees, despite handing out well over $5 million of juvenile fines and fees. Data from 2020 shows us that Kansas has collected a little bit less than $500,000. We've heard testimony today from a fellow proponent that it's now even dropped to $300,000 or thereabouts in terms of what we are collecting in juvenile fines and fees. The impact of this that we also see, as I mentioned earlier, professionally, is that we are finding our law enforcement officers are having to spend large amounts of time processing this paperwork, going out and trying to seek out these juveniles, their parents, so on and so forth. And there has been data from that I have cited here today in both my written testimony and in some oral testimony here that was written by a retired sheriff, Curry Myers. He is a retired Kansas sheriff. He has submitted some written testimony of his own that should be in your packets. But a paper that he published about a year ago examined the impact of agencies and governments that have a significant reliance over-reliance on fines and fees and the utilization of them, and found that there is actually evidence to suggest that this has had decreasing and negative impacts on public safety, and in particular around the percentage of crimes that are being solved as more time is being taken up by our police officers having to effectively act as debt collectors rather than focus on the meaningful work that we know that they would love to do and that we want them doing for greater public safety and greater integration in our communities. At the end of the day, 5 other states have fully eliminated juvenile fines and fees, while 7 others, including Texas and Utah, have either fully ended or heavily capped the fees and fines within their juvenile systems. And a bevy of evidence suggests that investing in a number of other methods, whether that be diversion, community service, work hours, so on and so forth, have a much greater results of breaking a cycle of recidivism and creating a pathway for a justice system that is not only strong in our convictions and principles, but allows for an opportunity of reentry and rehabilitation, in particular for our juveniles. On a final note, as has briefly been touched on by the chairman and a number of conversations with fellow coalition partners and agencies that are involved and invested in this particular bill, we did find that there could be an opportunity to tighten language revolving or concerning restitution. As it was stated earlier, our intention is not to impact that. We understand that that is a vital piece of our criminal justice system and hope to continue to allow that to serve its role. But as said, the accumulation of these additional fines and fees, we believe we now have an opportunity to help really invest money otherwise spent there into more effective, data-driven resources, be strong in our convictions and principles as a criminal justice system, but be smart on crime about this. So with that, ladies and gentlemen, thank you so much, and I'll be happy to take questions at the appropriate time.
Thank you, sir. All right, we'll now have Jamie Kavanaugh, attorney for the Institute of Justice, who will be joining us on WebEx.
Thank you, Chairman Owens. Good afternoon, and members of the committee. Thank you for considering HP 2073. My name is Jamie Kavanaugh. I'm an attorney with the Institute for Justice. Since 1991, IJ has been fighting both in courts and at state houses to protect personal freedoms and individual liberty. As part of this work, IJ is interested in protecting private property interests, and this involves challenging government misuse of fines and fees. So for example, in 2019, IJ won the landmark case, Timms v. State of Indiana, at the US Supreme Court. There, the court ruled that the 8th Amendment's prohibition on excessive fines is incorporated against the states. IJ is also interested in ensuring that the government doesn't misuse the natural profit incentive associated with fines and fees. So fines and fees should not be used as a blank check to increase government budgets without raising taxes. So I'd like to make 2 points in support of this bill today. First, ending youth fines and fees aligns with the goals of the juvenile justice system. And second, simple economic support eliminating youth fines and fees. First, the goal of the juvenile justice system, as we've heard today, is to rehabilitate youth and set them up for success as adults. Kids who make mistakes should be able to learn to do better, but charging youth fines and fees simply creates another hurdle to future success. And Kansas charges more fines and fees to youth and their families than almost any other state. But being poor isn't a crime, and the system shouldn't be treating some youth worse because of their inability to pay fines and fees. It's also unrealistic to think that youth have a way to pay court debt. And overall, the system should be encouraging children and youth to focus on their education instead of getting jobs to pay down court debt. Others may believe that children should rely on their families to help with this court debt, but when families don't have the resources to help, tension and resentment can build. There's data showing that this tension and resentment can destabilize family relationships and create tension at home, arguably when youth need stability at home the most. So in reality, as we've heard today, research shows that many young people with court debt will turn back to crime. Imposing fines and fees does not stop crime, Just the opposite, it increases recidivism. And youth who are unable to pay fines and fees are more likely to end up incarcerated in the future. So instead of supporting youth, fines and fees often set them up for failure. Second, the basic economics support repeal of youth fines and fees. We've heard today a number of statistics that court debt is expensive to manage and collect. I'll just note that there was more data from LA County that's similar to what we've heard from Oregon and Texas and New Mexico that confirms that it costs just as much to collect juvenile fines and fees, and that counties aren't actually making any money off of what they're assessing. And I'll note that Kansas collected only $539,000 in youth fines and fees in 2020, which is a number that's been steadily declining since 2016, and an amount that isn't significant to the state, but the individual assessments to youth and their families can be devastating. So again, around the country, there's strong bipartisan support for eliminating youth fines and fees, and Kansas should join states like Oklahoma, Texas, and Louisiana that have ended youth fines and fees. I'd urge this committee to support this bill. And thank you for your time.
Thank you very much, Jamie. All right, we'll now hear from Desmond Bryant White, Program Manager of Progeny and Destination Innovation, Inc. Desmond, welcome to the committee.
Thank you for having me. Hope everybody's having a good afternoon. My name is Desmond Bryant. I am the manager of Progeny, a program of Destination Innovation. Progeny is a youth-adult partnership focused on reimagining the juvenile justice system and in reinvesting into community-based alternatives. We believe every child in the juvenile justice system deserves justice and respect. That in order to make a safe and thriving community, we must address the root causes of harm and collectively to make those changes. Fines and fees affected my life after I had already turned 18. However, a lot of those fees happened over 15 years ago, and they are still lingering over my life today. I am still trying to pay off some of those fees and get my life back together while continuously learning and trying to be a positive influence in the community. It's unfortunate that most of these circumstances derived from being profiled while driving. Rather it be a dim taillight or failing to signal 100 feet from a stop sign. Usually something small or non-violent that can destroy a young person or a family's life that are unable to pay these fines and fees from a simple traffic stop. So I can only imagine the stress and the anguish that fines and fees can put on a family that does not have the money to pay those fees. As an adult that has been there and back, I think it's safe to say that the system as it is not giving youth a fair chance at a successful future. When we think about the amount of resources that it takes to collect these fines and fees versus the amount of resources that we invest back in the community, as leaders, we should be embarrassed. When young people and their families aren't unable to afford these court fees and other costs, there are cases that are kept open longer and solely for missed payments or missed school or work for the payments related to these court dates. Young people can face heavy loads of debt, civil judgment, and even ruin credit, limiting these opportunities for years to come. Children don't pay bills. Children don't have jobs. But by requiring juveniles to pay fines and fees at every step of the court process, we place a burden and harsh punishments on working families, many of those who already live paycheck to paycheck, trapping them inside of a cycle of debt. Kansas court, again, they charge children in the legal system and their families thousands of dollars of unjust fees at every step of the court process. These financial penalties undermine public safety and family stability, punish poverty, and deepen existing racial and economic disparities, and set young people to fail for years to come. Kansas legislators have the power and the responsibility to effectively and immediately correct the juvenile fines systems by passing the Debt-Free Justice for Youth Act. I ask that we don't forget about the youth who don't have a voice, that we don't forget about the youth that are underrepresented, that we don't forget about the youth that are marginalized because they cannot pay fines and fees from a simple mistake. Instead, we charge them fines and fees that they can't pay, which stresses out families during very hard times. When you have to make a choice between paying your rent and your child's freedom, when you have to make a choice between feeding your child, feeding your other children, or paying fees for your other children, those are choices that no parent should have to make in the first place, in my opinion. With Progeny, our goal is to consistently reimagine the juvenile justice system and what it looks like. As leaders, we actually have the power to do just that. We can set up our youth for success with this bill, not a cycle of debt. And please, I ask you to do what we can to pass HB 2073 and eliminate fines and fees in this session. We are an outlier on this issue. We can follow the path such as Louisiana, which passed this bill unanimously. This bill is something that I hope all people can get behind. Young Kansans are our future, and we must constantly ask ourselves, are we doing everything in our power to do what we can to put our youth in a successful position? For what we do today shapes our tomorrow. So I ask you again, what are we doing as leaders to put our youth in a better position? Thank you.
Thank you very much, Desmond. All right, we're now pleased to hear from Dante Bristow, Progeny Youth Leader, also with Destination Innovation, Inc. Dante?
Hello, everyone. Thank you for having me. My name is Dante Bristow. I myself am a youth leader with Progeny. I grew up in the system, young. And if you know, you go through these court fines, every step of the way, they're charging you every step of the way for fines, whether it's court fines, probation fines, UA fines. All these fines are being charged to you every step of the way. The poor, which is the blacker the communities, we tend not to have money. We're considered poor. If we can't pay for these fines and fees, we get stuck in the cycle. And if we're stuck in a cycle, it's just going to keep racking up on us. We can't get out because we don't have any money. We're just going to keep being in that cycle. Probation fines will put you in jail for fines and fees. These fines and fees have put me in jail. I remember being young, I was on a bracelet. I got locked up because I couldn't pay these fines and fees for my bracelet, just for them to let me right back out on the same bracelet I couldn't pay for. I'm 24 years old now, and still to this day I have a hard time passing the background check because of these fines and fees. Things that I did when I was a juvenile, under 16 years old. I feel like I can't live a normal life because I'm constantly having to pay for these fines and fees, or looking over my shoulder for being incarcerated because I can't pay for these fines and fees. It's hard, especially when you have kids or bills to pay for. Fines and fees can be something that hurts you. It affects your ability to get jobs because if you can't pay for these fines and fees, you can't get enough money to save up to expunge your criminal history for these fines and fees that you did. If you don't pay for these fines and fees, it can haunt you. I remember getting off the bracelet. I moved my family to Toledo, Ohio. I got away from this lifestyle that I was living down here in Kansas. They said they wanted me to get a job. They said they wanted me to do right, do taxes, do everything right. I was doing that. They came down to Toledo, Ohio, and got me and brought me back. When I finally broke the cycle, I felt like I broke the cycle. I felt like my life was finally getting to normal. But because of these fines and fees and things that I did when I was a juvenile, they brought me back to Kansas. I don't want to keep seeing that happen to the youth, especially for something that can keep going on for 5 to 10 years. That's your life. It feels like being on a leash. I'm 24 years old now and still have trouble because of things I've had done when I was a juvenile. No youth should be punished for these fines and fees I was punished for. I don't want to see youth being punished for these fines and fees. I remember I had an option to go to school and risk going to jail because I can't pay for these fines and fees, or dropping out of school and getting a job to pay for these fines and fees so I don't go to jail. And I was one of the ones that picked dropping out of school to get a job because I couldn't pay for these fines and fees. They're locking us up for this use. So that's my testimony.
Thank you very much, Dante. All right, now I'll be pleased to hear from Mike Funkert, Campaign Director, Kansas Appleseed Center for Law and Justice. Welcome to the committee, Mike.
Thank you, Mr. Chairman. Vice Chair Smith, members of the committee, thank you so much for the opportunity to speak here today. You've already heard a lot of great testimony, so I won't waste your time just repeating the same things. You can reference my written testimony for citations, facts. But what I wanted to just get up here and say today is, when you look at the folks that are here to support this, you can see all across the spectrum we've got support. We've got other states that have done this successfully, and we've got a very small budgetary impact that we are confident that we can find ways to meet those needs without assessing fines and fees to young people. And so I just wanted to take this opportunity to thank all of the great folks that are in this room today, representing this bill, fighting for this bill. Thank Chairman Owens for the many hours that we've spent talking about this over the last several years and working on making sure it's in a good spot that can get support for the whole legislature. So I'm really proud of this effort. It is absolutely an exercise in bipartisanship, and that feels great to be part of that. And so thanks to everybody. I really encourage support for this, and just know that if along the way we find any language tweaks that need to happen, we're here to work it out. This is a bill that really needs to get done this year, and we're here to make that happen. So our intent here is just to make sure justice-involved kids aren't burdened by fines and fees, and they can focus on doing what they need to set themselves up for success. So thank you so much, and I'll stand for any questions at the appropriate time.
Thank you, Mike. And our last proponent to testify is Aileen Berquist, with Policy Director, ACLU of Kansas.
Thank you, Chair.
Get away.
And Vice Chair and Ranking Member, and thank you to everyone on the committee who has either heard about this ad nauseum from us for years or who is just hearing about this for the first time. I will not spend any more time other than to say that this has been a labor of love, and we really hope that the tremendous bipartisan work that has been done will continue so that there can be a really positive impact in the lives of Kansas kids and their families. So thank you, and we are all available to you as resources should you have questions.
Very good. Thank you. All right, committee, do we have questions for our proponents? Representative Carmichael.
Thank you, Mr. Chairman. As the members of this committee no doubt know, I am often too quick to criticize and too slow to offer thanks and recognition. I want to offer some recognition to the men and women of Progeny who put a face on this issue for me. But for some of your efforts, I would not have realized how important it is to do what I think we're about to do here. I also want to express some appreciation to the people from the Justice Action Network, Mr. Bean, to Kansas Appleseed, Mr. Funkert, and yes, to Mr. Luth from Americans for Prosperity for showing that there is a way that we can do this. And it's a wonderful bipartisan coalition. It's going to make me so happy if we can get this done. That being said, here's my question. The Judiciary Committee over the past several years has passed a series of bills that have to do with collection of fines and fees, both at the adult level and I think probably at the juvenile level as well, but I don't know. And I also know that we have even taken some of those legislation to the point that we convert these debts into civil judgments, and these debts are being collected by collection lawyers who are being paid on contingency fee basis in many instances. And there's nothing wrong with lawyers getting paid. I want lawyers to get paid. I am one. But does anyone in here know, do those collection lawyer statutes also apply to juvenile fines and fees, and do those juvenile fines and fees convert into civil judgments as well? Or is that just being limited to adult fines, fees, and costs? And if nobody knows offhand, I'd ask legislative research take a look with the chair's permission and perhaps report back to the committee so that we know what's going on here. But if there's somebody who has an immediate answer, I'd like to hear it. And there is one final question that I have in mind.
Sure. Does anybody have an answer to that one? I didn't really think so. So we'll leave that one up to legislative research to return and report to us.
Yeah, and then with your leave, Mr. Chair, I'd ask they report back to you, and then you share it with us all as you feel or deem appropriate.
I most certainly will.
My final question, and my hope is that the reviser does have this one quickly at hand. Is this legislation only prospective, or is it retrospective, so that people we've heard from here today who have debt that may be 10 or 15 years old, are we wiping out that debt? Can we wipe out that debt? Because I know the collection lawyers were upset one time that once they got this case assigned to, the cases assigned to them, they didn't ever want us to cancel the debt because they've worked on it trying to collect it.
We'll ask Natalie that question.
Thank you, Mr. Chairman. Representative Carmichael, I would point you to, on page 1, subsection B, paragraph 1, provides that any outstanding fine, fee, cost, the whole list, at the end of that says shall be discharged and shall not be collected. So on the effective date of the act, I think that anything that's outstanding that would otherwise fall under this section would be discharged and would no longer be collected.
There you go.
Meaning that it has retrospective application and the reviser is satisfied that our intent in that regard is appropriately placed in black and white.
Mr. Chairman, I believe it is. Obviously, attorneys disagree
Sure.
all the time.
And it's also embarrassing when the answer to a lawyer's question appears on page 1, paragraph 1, line 1. Thank you very much, Mr. Chair.
There we have it. All right. Representative Martinez, go right ahead.
Thank you, Mr. Chairman. And thank you guys for coming and giving your testimony. I have one question. We do away with fines and fees for offenses and things like that. Is that like the first offense or the second offense? If you go and reoffend, is that like for every time, or how does that work?
Natalie could probably answer that one as well.
Mr. Chairman, there are several points throughout the juvenile justice system where fines can be imposed. So starting from the time when law enforcement takes a juvenile into custody, takes them to juvenile assessment and intake, all the way through post-sentencing, your appeals. So there's lots of fines that can be imposed throughout the entirety of the system.
Okay. I think Aileen Berquist would like to answer that one as well. Go ahead.
Apologize, Representative Carmichael, that we didn't have the answer immediately at hand, but someone watching online from the Juvenile Law Center wanted to share that the statutes do convert to civil judgments right now, and the debt does go to private collections attorneys. And if you would like to see some of those contracts that show the percentage that's added on for that collection, we would be happy to share it.
Mr. Chair, with your permission, just one quick follow-up. One of the things I can't remember is those lawyers' fees, are they added on or are they deducted from the remittance that goes to the courts? But
that's something I think Natalie would need to
get in touch with me. We'll work through these issues, and I know legislative research will be of assistance to us all. Thank you.
Representative Martinez, I thought she was going to speak to your question, and so did you get the answer that you were looking for?
So I guess my question is, so that I realize that all fees that can be assessed during one offense, let's just say there's another offense.
Mr. Chairman, so each offense would have their own separate fees associated with it throughout the whole system.
But they would not be able to be assessed if this became law.
Correct. If this bill became law, no juvenile offense, no juvenile who's adjudicated as a juvenile under the Juvenile Offender Code would be assessed any fees.
In the event that there may be a repeat offender, no fees could be assessed. Okay. Thank you.
As long as that second case is under the juvenile offender code, not when they're an adult, or if they were to be waived to adult court.
Right, okay, thank you.
Committee, additional questions? Representative Mon.
Thank you, Mr. Chairman. This question is primarily to Noah, if you're still with us. But I'll be happy to hear anyone who can answer it. There was multiple references to a more reliable funding source than just juvenile fees and fines, et cetera. And I'm wondering what you're suggesting. Where is that additional funding source coming from? It seems to me that the rest of society kind of supports the juvenile justice system as it is. Are we adding additional burdens on the rest of society at the expense of this bill?
Thank you for the question, Representative. I'm happy to speak to that. Yes, the more reliable funding than gathering fines and fees from children, which again, referencing Americans for Prosperity is reference to a study that shows in Florida just 10% was collected. And again, Oregon spends more money collecting this than they do actually receiving the money. So it's a net loss for Oregon and potentially Kansas. But what that has then replaced in states that have eliminated fees with state general funds, the same way that the whole rest of the juvenile justice system is funded. So to the extent that you have, salaries of individuals who work in the juvenile justice system, to the extent that you have programs that young people must go through at the direction of the court, that's funded by appropriations from the legislature. And so in states like Louisiana, they simply removed this inefficient and potentially money-losing avenue and replaced it with the same revenue stream that funds the rest of their system. And that would also be the case here.
Thank you. Just one more follow-up. I'm at a loss to figure out how it costs almost as much or more to collect something that is generally collected on a contingency type basis than it does to actually assess the fines. I also would just want to clarify a little bit. So you're suggesting, and looking at the numbers, between almost 400,000 and 600,000, that we add that to the burden of the taxpayers of Kansas at the expense of juvenile offenders. Is that where we're going with this?
That is what the states that have enacted fees have done. And the notion is that you just continue to fund your juvenile justice system the rest of the way that you do. In terms of why states are losing money in the collection, there are costs inherent, the time and resources of county clerks and others that would be better spent dealing with the operations of those counties. I can look at the studies that deduce that loss in revenue in Oregon and other places and pull some of the factors that led to that loss to the taxpayers. They've broken that down, and I'd be happy to collect that to your question.
Oh, go ahead.
And Noah, this one may not exactly be for you, but it's for anyone who may be able to answer. Does anyone know how often probation is revoked solely because a juvenile has not paid fines, fees, costs, etc.? So the specter of having juveniles be placed in custody because they haven't paid their fines, fees, etc., has been raised, and I just like to know if anyone does know how often that actually occurs, because it appears to me to be unconstitutional under Bearden versus Georgia, and in Kansas, State v. Duke, which was a 1985 case. Bearden versus Georgia is a U.S. Supreme Court case out of 1983. So if anyone knows the answer to that question, I'd appreciate getting it.
Does anyone want to take that one up? Maybe we'll see if we can add that to research's plate as well and get that information back to us. I would be surprised if that happens much, especially under the new juvenile justice reforms that were passed under 367, but we'll still double check that. Representative Smith.
Thank you, Mr. Chair. Mine are really just a couple of comments. The first is, I think I would be equally disappointed if I found out coming to this that we were making some type of 30% profit or something off of these. I think that would be very disappointing to me as well. It's almost a relief to know that we're losing money a little bit on this punitive action that we put on people. Having said that, you know, as a law enforcement officer on patrol for 19 years, I can not count the number of times sitting down with an individual, a young child or kid out on the street and explaining to them, what good is it going to do me to write you this ticket? Mom and dad are going to have to pay this. They can't afford to pay for it right now. And look at what you're doing. You know, those are the conversations that maybe I'm afforded in a small community, a smaller community, that you don't often see out there. It begs the question of what do we do from here as far as punitive action, but certainly the unintended consequences of putting fines and fees on young people is evident. And I want to applaud you. This is the crux of my comment. I want to applaud you for coming in here. I know it makes you nervous to stand up. And sometimes I'm nervous standing up in front of these people and talking to them. So I get it, coming in here and admitting that you made a mistake some point in your life, but you're still paying for that mistake, and it's not fair. Thank you for coming in. Thank you for putting that together, and thank you for letting us share that with you. Thank you.
Representative Butler.
Thank you, Mr. Chairman. As a company commander in the Army, and I'd have young soldiers come in that were 18, 19 years old who made a mistake, and knowing that they were going to stand in a position of attention in front of me, and I adjudicated some kind of form of punishment on them. One of the things I learned from a wise NCO that I had was if I take money from them, they just continue to spiral down. And they'll be back because they couldn't pay a bill or they couldn't do those things. And it was always something I learned, and I think it was good. And so sitting and listening to this, I think this is where we're at right now, I think will lend itself to helping youth to be able to climb out of some of those holes. And to follow on with what Representative Smith said, thank you for coming out here. But I guess the next question of that, to follow on that, is of those here that either testified or did not testify that may be here, if this was to be enacted and those fines or those costs be taken away, how many of that would affect you, or if that was taken away? Thank you.
Go right ahead. Yeah, just repeat your name if you would. No, you're good. Just repeat your name in the microphone.
My name is Desmond Bryan, manager of Progeny. And I just wanted to shed light on the purpose of investing in the community. I don't think we should focus on how much the state would lose from this bill, because how much are we going to gain from it as people? If they said the state was making 30% more on youth, what is that number though, right? But I think we are in a very unique position to create change, you know, as leaders and for the youth. We're really putting ourselves as staple of the country. You know, I think as leaders, you know, we all gonna die one day and God gonna ask us, you know, what good did you do in your life? And if everybody in this room could say HB 2073, you know, that would be a blessing. So I just wanted to, you know, shed light on invest, don't arrest, and just how important it is to, you know, if we can move some of that money from receiving those funds and create more opportunities, you know, such as this. If it wasn't for Progeny and programs like Progeny, we wouldn't be here, and that serves to ask, what would we be doing? And I just want to, you know, place that seat with y'all, invest, don't arrest.
Thank you. Representative Schlingensieben.
Thank you, Mr. Chairman. It sounds to me like we're going to be having a lot more taxpayers in the state of Kansas if this goes through potentially, which might be a source of additional revenue. But how many of you vote? I really hope that we can do something in this legislature that says to you, you can change the future if you elect people to represent you, and if you come to a place like this and share your stories. I really hope that what we do will increase your confidence in your ability to have power and your ability to stand up for things that are right and to make other changes in your communities as well. It's a proud moment to be able to stand up and do what you're doing here today, and I thank you for it.
Additional Representative Mon.
Thank you, Mr. Chairman. This question is for any of the conferees. Do we know what percentage of juvenile offenders are from below the poverty line? We seem to be focusing a lot on the hardship that this will impose on those who are below the poverty line, but I know that not all juvenile offenders are below the poverty line, and I do agree that there should be some discretion in the courts to forgive fines and fees and costs for those who are indigent and or cannot afford to pay them or have repeatedly shown an inability to do so. But you know, there are a significant number of juvenile offenders who come from wealthy or middle-class families, and it just doesn't seem to make sense that they get to take advantage of the same type of across-the-board forgiveness. So if anyone knows the answer to that or can kind of point me in the right direction, I'd appreciate it.
We'll see if we get it right. Eileen Berquist, as Representative Heiberger has corrected me.
Thank you, I appreciate that. So I'm hearing from the Juvenile Law Center again. They decided not to give you the same testimony that you've already heard, but 60% of families nationwide with children in the juvenile justice system make $20K or less a year, and that's total family income. This is coming from a Galt Center report. That's previously the National Juvenile Defender Center. So it is a significant number.
Thank you. Additional questions? All right, well, sorry, Representative Turk.
Sorry, one more.
No, you're good.
The representative from the ACLU, maybe you can help me with this one. What is the timeline on the transition to civil court that those cases go to acquire the fines?
That is a really good question that we would need to follow up on.
Okay, got one more question if I'm allowed. Is there any language in this particular bill that addresses the cases already transitioned into civil court to acquire these fines? How do we, I want to know how far the thread goes, if you will.
Go ahead, Natalie.
Mr. Chairman, and this goes to a little bit what Representative Carmichael was talking about too, and I would be curious to talk about this with the ACLU afterwards, but there was actually a court case last year here that basically said you cannot take those criminal orders and convert them to civil orders to collect. And so I think that's what Representative Carmichael was talking about. We had a bill about that in judiciary. That bill passed. So we actually have repealed the statutes that allow the conversion of that into a civil judgment. We do still, though, allow the collections to happen for all of these fines, fees, restitution by collections agencies. The mechanism for doing that has just changed. I would suspect there would be litigation over that, but I don't know if that's started yet. So I think it's going to be really hard to find the exact information, but we could definitely try to reach out to someone over in the court system to see if there's any updates on that.
Good. All right. Well, committee, thank you guys very much. I do want to, for your knowledge, take a few minutes. There's a handful of written proponents. James Houston Bales, Public Defender, State Board of Indigent Defense. Karuva Kaseke, Fiscal Policy Analyst, Kansas Action for Children. Retired Sheriff Curry Myers, Americans for Prosperity. Lindsay Smith, Staff Attorney, Juvenile Law Center. Kansas Advisory Group Executive Committee. Katrina Goodjoint with the Luth Policy Council, the Galt Center, and Logan Bird, who's a private citizen. All submitted written proponent testimony for your reading. I do not show any neutral or opponent testimony. Is there anybody here wishing to speak to that effect? All right, seeing none. I'm the one that gets the last word in this committee, and I too would like to express my thanks. I have been young before. I have made mistakes. We won't go into any of those details at this time, but suffice it to say, I know how hard it is to stand up in front of a group of people in this building. It's a magnificent place. But never forget that this is the people's building, right? This is your building. This isn't any more our building than it is yours, and you have every right to be here, and I'm grateful that you took the time and developed the courage to stand up and to share your stories and to help us understand what many of us may not understand, a different point of view. So thank you all for that and for putting that together. With that in mind, we'll go ahead and close the hearing on House Bill 2073. And we will move into final action on House Bill 2033 and ask Natalie to give us an overview.
Sorry, Mr. Chairman, I'm out of practice of getting all my stuff ready.
Sorry.
Mr. Chairman, House Bill 2033 would change the criteria that's used to refer and admit juveniles to a juvenile crisis intervention center.
Very good. Representative Heiberger has a question.
Thank you, and I apologize for missing most of the hearing on this. So if I'm asking things that have already been asked, I apologize. But Natalie, does the term behavioral health crisis, does that encompass mental health crisis? Is that accurate?
Mr. Chairman, I believe it would. If you look at the definition, if you have the bill in front of you, it is on page 6, starting at line 17. And so it lists the things that it means, but it does say including but not limited to life-threatening mental health issues and substance abuse concerns. So I believe the intention is to include that.
That was my reading too. I just wanted to get your take on it. And this is maybe trivial, but on page 18 of the bill, there's some text that's run together. It's on both the printed and the online version. And I think it's readable, but I just want to make sure that this isn't going to impair the validity of our adoption.
Yeah, are you talking about the stuff starting in line 10?
Yes.
Yeah, it's really weird. I've never seen that before. I don't think that there will be any issues with it, but we can talk to Chamber and see if it needs to be reprinted.
All right, thank you very much. All right, committee, further discussion or any amendments as it relates to House Bill 2033?
Mr. Chairman, I move that the House recommend House Bill 2033 favorable for passage.
All right, very good. Do I have a second? Representative Turk. Any additional discussion?
Mr. Chairman.
No, Representative Mon.
I just want to register that I will be voting against this. The behavioral health crisis definition is so broad as to pretty much impact anything that a child does that is bad behavior that impacts their safety or health. I think that could be anything from smoking to drinking to just acting out. I just think this is way too broad and will open up the funnel for who is available to go into one of these mental health or these youth, one of these intervention centers to be so broad as to be unworkable, in my opinion.
Additional comments? All right, committee, we have a motion and a second. All in favor of moving House Bill 2033 out favorably, say aye. Aye. All opposed, no. All right, very good. Representative Heiberger and Representative Carmichael wish to have their votes recorded as an aye. This does pass, and we will move that out to the floor. With that in mind, committee, no meeting tomorrow, but we'll be back on Monday. And I thank you for your time, and we are adjourned.